Uh, okay, so we can start. Hi, everyone. Thank you for joining us at this Hikma conference. We are on the second day of the summit, and today we will have the pleasure to speak with a high-standing personality for international law, Bruno Simma. It's a pleasure to meet you and have the opportunity to speak with you. Thank you for your participation to this new project of Hikma. As you all know, we have to change our initial project from, a summit, a real summit to an online summit, but we can make it, so we are really happy. And now I'd like to introduce Bruno Simma briefly to our audience and then introduce our second guest. Judge Simma is obviously a judge at the Iran-United States Claims Tribunal in the EU, and before his appointment to the tribunal, Simma served as a judge at the International Court of Justice from 2003 until 2012, and before this he was a member of the UN Committee of Economic, Social and Cultural Rights. Obviously, Bruno Simma has also had a long and distinguished academic career as a professor of law at the University of Munich from over 30 years. He's also a co-founder and co-editor of the European Journal of International Law and a co-founder of the European Society of International Law and a member of the Institut des droits internationaux. And not only that, I could continue to talk about, Professor Simma's career, but we don't have all this time, unfortunately. And let's pass to our second guest. Professor Tanzi is a professor of international law at the University of Bologna, and he has also been member of the list of arbitrators of Permanent Court of Arbitration and conciliator of the Court of Conciliation and Arbitration of the OSCE, and he participated several times in the work of the Sixth Commission of the United Nations General Assembly as a member of the Italian delegation. Okay, Professor Tanzi will play the role of moderator in this conference, asking questions and activating a dialogue with Bruno Simma. And the conference will be structured in two moments. An initial moment will be more, theoretical. Bruno Simma and Attila Tanzi will start to have a sort of conversation instead of a lesson, and this first part will take probably more than an hour, and after all this discussion, around 10 minutes will be dedicated to your question. You can send us via the Q&A space, and the question will be selected and then delivered to the moderator. Now I can leave the word to our guest.
Well, thank you very much, Matilde, for giving me the floor, but mostly for inviting me to undertake this role as a moderator and adding my kind words of welcome rather enthusiastically to Judge and Professor Bruno Simma, who happened to be a very close friend next to a model for my career and in his personal and professional developments ever since 1982. We shouldn't say that date, which is a long time ago. Next to everything you said about Judge Simma, truly Bruno Simma is one of the greatest living international lawyers, both under the hat of his academic activity as well as that of his professional achievements. And he managed to combine both, to putting both parts, aspects of its careers to the best of services to the other. And another feature of Judge Simma, Professor Simma, Bruno, is that he has always managed, despite the risk of issue conflicts, to speak his mind during conferences and in his writings, because he continues to write and research international law, managing to benefit from the full confidence of countries, companies from different quarters, benefiting from their confidence in his impartiality, integrity, and independence. And those are words that are absolutely coming from my heart and true intellectual conviction. So it is a great honor and pleasure to be sitting virtually together with Bruno Simma online. Thank you very much, Bruno, for being with us. Bruno, I propose, considering the kind of interest that I understand characterize our audience today, to try and follow two intertwined red threads for our chat. The first one would be the interaction between international relations, namely international political relations on the one hand, and international adjudication, of which you have been a significant participant on the other. The second string that I believe is of great interest to our audience is the role of non-state actors in international adjudication. Again, particularly with regard to the ICJ, but not exclusively. And obviously, talking about non-state actors bring us to the protection of fundamental human rights and freedoms for individuals and groups of individuals. Now, if we want to start from the most recent and rather extraordinary case that has been brought before the International Court of Justice, which epitomizes the entanglement between foreign relations aspects and the protection of human rights, is the case that the Gambia, of all countries, in November last year, brought against Myanmar for conduct allegedly tainted with genocide. Now, Canada and the Netherlands have recently announced that they will intervene as third parties in the proceedings. Now, Bruno, what is your sense about this case, both in terms of protection of human rights, the protection of the Rohingya minority, and about the foreign relations impact between the countries involved and other potential countries that may intervene in the case? Bruno.
Attila, before I start, let me thank you particularly for your introduction. I hope I will have a chance to retaliate with equally friendly and flattering descriptions. Thank you very much. Actually, we have been friends for almost more than 30 years, let me mention that. So it's really a pleasure to have you as a moderator here. And I'd also like the summit, the organization, for inviting me. It's a real pleasure to be in Italy in a virtual sense, which is my favorite foreign country, actually. Now to your question, I think this is, of course, it's a good choice because it's a fascinating case. It's actually not the first time that such a problem landed in the lap of the International Court of Justice. The case has certain similarities with a case which Belgium brought against Senegal a few years ago. The new thing about that case is here we have a country which does not go to The Hague to claim rights of its own that have been violated by another country, like two big farmers, fighting over where the exact boundary line between their land runs, that is fighting for their own interests. You have a country which is not personally injured by what happened in Myanmar, but it takes the lead. It is joined by other countries. And so you'll have, this is really a first time in the history of the court that you have 3 states joining together, Canada and the Netherlands intervening on the side of Gambia in that case against Myanmar. So of course, I have all my academic life, been interested in precisely the kind of questions that come up in that context, namely, to what degree can we recognize in modern international law what I called in a publication the way from bilateralism to community interest. I think cases like Belgium against Senegal, and particularly the Gambia against Myanmar, are cases which symbolize that there is also, before the International Court of Justice, there is a transition, a development away from the strict bilateralism, which was the, let's say, the trademark of traditional international law, and particularly expressed, particularly strict before the International Court of Justice. So my reaction is, why? What a great case. I would have liked to be involved. I'll be involved mentally. I'll watch everything that you can see on the website about the case. But the case, of course, also has its question marks. You see, the International Court of Justice always has to establish that it has jurisdiction in a case. That is, that states actually have the right to go before the court. And the International Court of Justice only has that jurisdiction if states have agreed to it. Very different from a domestic court, very different from the European Court of Human Rights or the European Court of the European Communities. The ICJ is actually an old court. It will turn 100 years very soon. So it's and in the 1920s, when the court was established, the kind of let's say adjudication involving a number of states fighting not for their own borders, for their own interests, but for the let's say the protection of the inhabitants of the citizens of a different country would have been virtually unknown, and this international lawyer would have said, forget about it, that is not possible. So the court, in our case, in this court, does have jurisdiction on the basis of a convention, actually the first human rights convention ever adopted at the United Nations, the so-called Convention or Genocide Convention, Convention on the Prohibition and of Genocide, combating genocide, which has a clause, an article which says states can bring each other before the International Court of Justice on bring accusations of genocide. This means that the jurisdiction is limited to genocide, which means if the ICJ in the further course of this case would arrive at the result that what we have before us is, of course, terrible, massive human rights violations, but not crimes which have that special attribute that you need for mass crimes to grow into genocide, then there is no jurisdiction, and the court cannot say, okay, Gambia, well, we don't find that Myanmar has committed genocide, but we can find that the court has violated, has, let's say, committed war crimes, crimes against humanity. That is not possible. The court can only say, yes, this is genocide, or I don't have jurisdiction to say anything else. Now, what is the special element of genocide? And the court has clarified that in a couple of cases. In one of them, I participated, and that special element is a special intent, namely to eliminate people, persecute people, to kill them, to whatever, with the intention to eliminate the group as such. So, for instance, the ICJ has found in a case brought by Croatia against Serbia, decided maybe about 10 years ago, that no genocide happened in the face of the Yugoslavia war in the 1990s, when Serbia invaded Croatia. Terrible things happened, but the court said there might have been ethnic cleansing, that is, the intention by Serbia to drive away from their land whole populations in order to make these populations more or less freedom for Serbs. This is not enough. It's not enough. It's not enough to frighten an ethnic population. It's not enough to kill their members, etc. It has to be done with the special intent to really eliminate the group as such, not just to drive them away. And this, of course, will be the big problem with all genocide cases before the ICJ. And this will also be a big problem for the case of Myanmar, brought by the Gambia against Myanmar. But Attila, what this also shows is that maybe states go before the ICJ for claiming that they are going there in order to combat genocide committed against the Rohingya people by the government, by the armed forces of Myanmar. But maybe they say, all right, we recognize we can easily lose that case because the court might not find that special intent. But still, the case will be the result will be in our favor. The world will know what happened there. So there is a wider purpose. And this would be a thought in connection with the, let's say, what role does the ICJ or international adjudications play in international diplomacy, that sometimes going to the court is a means that serves a much wider political purpose. For instance, to build up pressure on a state, or let's say avoid. Yeah, okay. Maybe I'll stop at that moment and let you ask, because otherwise I'll fall into a monologue. Okay.
Thank you very much, Bruno. Well, that was very interesting, and I think we can go on along the lines of issues related to this case. As I see it, and maybe you would like to comment on this, a political aspect which may be very much behind your statement, whereby a state introduces a case against another state on a particular legal issue with the view to putting pressure on a wider political situation. I see as a possibility here, probably this accounts for the fact that we have the applicant case coming from a continent other than that where the defendant is situated, where you have a political interest which is very much entangled with racial and religious minority issues, insofar as we have in this Muslim country suing a state whose prevailing religion in that country is non-Muslim, persecuting a Muslim minority. And there is an interesting addition to the political interstate usual kind of enjeu in the affair is the religious element. Would you say that this religious element may play an element of novelty with regard to the usual interstate policy games? And would you say that this might have an impact in the future in interreligious relations in international affairs?
That's a very interesting question, but also I would say a difficult question to answer. It is interesting. You see that you have the Gambia, which is a Muslim country, and then you have an organization which is involved in the let's say political preparation of the case, namely the Organization of Islamic Countries, which actually also leads to interesting legal questions. Is it the Gambia there, or is that some kind of a collective action against Myanmar? And of course, if that were the case, we would have problem again with the jurisdiction, because only states can appear before the International Court of Justice and not international organizations as claimants. So, but I think the role that the OEC has played in that case does not really endanger the status of the Gambia as a party. But of course, you see there very clearly the religious element. What I find interesting is the following. We have that new phenomenon that states can go to the International Court and enforce, let's say, a prohibition on genocide, etc. They don't have to be affected in their individual interests. But if you look close at the small number of cases that you have, like also the case of Belgium against Senegal, you realize there is always a little, how should I say, just a little relict, a little remainder of the old instinct before the ICJ. And the real instinct in cases before the ICJ is that if states go before the ICJ to claim the rights of human beings, it has traditionally been the rights of their own nationals. So states can engage in diplomatic protection of the rights of their nationals, and they can do it by going to the ICJ. Now, the great novelty is that certain obligations can be vindicated by states without this element that I do that for my own people. But if you look close, in the Belgium-Senegal case, you see an element which is rather traditional, which means that I have to explain. The Belgium-Senegal case was about a former dictator of the Chad who was kind of thrown out of the country and lived quite peacefully and comfortably in the Senegal. He had been the dictator, torturing, disappearing, killing lots of people in Chad. Some of these people had fled to Belgium during his time of his regime and had become Belgian nationals. And you see, there is this element. Okay, I do that for a higher purpose, but still there's a little bit left of the old picture where instinctively, if you do something, you do it for your own people and you don't do it for foreigners. And of course, the religious element also fits into that picture. In a way, Gambia wouldn't probably have gone to before the ICJ if it had been a case brought by the, let's say, or if against Canada because of the bad treatment of the Inuit by the Canadian government, or against Finland because they don't treat their, I don't know, how do you call the people there with their reindeers, etc. They wouldn't have done that because there is absolutely no connection. But in our cases, you still see a bit of connection, be it religious, be it ethnic. And I just wonder when we're going to see a case before the ICJ who is actually free of that little link that you still sense.
Well, thank you very much, Bruno. In fact, one of the objections to the jurisdiction of the court raised by Myanmar was precisely that of the case brought by the Gambia being funded by the Organization of Islamic States. The court rejected this objection, in fact, and I suppose it's interesting in terms of giving the connotation to this case of a case which genuinely operates genuinely in favor of the protection of a national minority, irrespective of its religion or ethnic identity, is the fact that, thank God, two states who are not Muslim states are intervening, because the prospect was, the idea that we would expect would be to have a series of Muslim states, one after the other, intervening, and that would have sensibly increased the interreligious color of this case. The fact that we have two non-Muslim states definitely adds to this, let's say, new sort of religious neutrality of the case. Bruno,
that's a very important, let's say, thing to be added to what I said. That, of course, the participation of Canada and the Netherlands takes away that little, let's say, not odor, but problem that this is just the Muslims fighting against the Buddhists. Very important. Yeah. Sorry, I interrupted you.
No, thank you very much, Bruno. Also, from my experience, Bruno, I think that an interesting general policy issue is whether international adjudication is to be considered as alternative. Is it alternative, or is it complementary to diplomacy as a means of dispute settlement? When I have been dealing with diplomats in situations of conflicts of interest with foreign countries, their attitude has always been very much on the defensive. I mean, they want to defend themselves from the prospect of going to litigation. But there are many a case before the ICJ, as I see it, or even before international interstate arbitration, in which it seems to me that going to arbitration or adjudication prove of tremendous help for the political solution of the dispute. If you take, for example, the way the Iran-United States Claims Tribunal has been brought about, has been established, that's the end product of a painstaking and thorough diplomatic process, and in a way, for a number of years, has been playing some sort of a cooling off role, despite ups and downs and despite the recent presidency. It's not for me to judge, but the Iran-United States Claims Tribunal is an example. The other one could be the Gabčíkovo-Najimaros case between Slovakia and Hungary, in which the parties agreed to go before the court, and the court in the end said, I give you some parameters for further negotiations. Whether it will be successful or not, many years have passed and much water has passed through the Danube River. But or the Palmills case, in which you have been involved as a judge between Argentina and Uruguay, led to an agreement 3 months after the rendering of the judgment, and to some extent also the India-Pakistan Kishan-Ganga arbitration. Perhaps also the jurisdictional immunities case between Germany and Italy was very much a diplomatic agreement to submit the case before the court. What is your sense, Bruno, about possible tensions on the one hand and synergies between adjudication and non-adjudicative means of dispute settlement?
Great topic for a seminar for one semester. 2 hours per week, actually fascinating. And I think if you kind of confront international adjudication like the ICJ and the international diplomacy, how they interact, what role does one of the two play for the other, then this would be would really fill an evening. I would say probably the prototype case is probably that there is two states do have a problem. They are in dispute over something, maybe a boundary, it may be an oil, a big oil in the Mediterranean, etc., etc. So maybe decades of negotiation or years of negotiation leading nowhere, and then at the end, maybe just out of fatigue, they they hand the case over to the international court. And I would say this is probably the prototype, let's say, like in boundary cases. But sometimes the relationship is much more, let's say, less simple and very surprising. And I think you referred to a case, and maybe I'll take that, or we can take that up in a bit more detail, which is actually was my last case as a judge before the ICJ, which is the case that Germany brought against Italy on the jurisdictional immunity of the state. Now, I don't know whether our participants are familiar with what this case was about. Attila, if you want to, maybe for your domestic audience, just explain the basis, then we can kind of cooperate about that. Just
Yeah.
And you can easily, if you want, you can do it in Italian, or just to make, so people will understand what we are talking about.
Right. Well, I'll try and summarize the case and the situation which was brought before the ICJ. Obviously, from my standpoint, and if you wish to interject at any point, please feel free to do so. Well, the issue, there is an international customary, very well established customary rule which provides that, which reflects the constitutional rule on the sovereign equality of states, whereby the domestic judge in one country cannot pass judgment on the conduct of a state, of a foreign state, conduct which has been performed in relation to its governmental powers. One exception has been brought about throughout the case concerning commercial activities. And this exception has been brought about because after the Soviet Revolution, Soviet countries did private business abroad through state-owned agencies. So the international customary rule on sovereign state immunity underwent an exception, a restriction, a limitation. What happened through the 1990s and beginning of this century, in the relatives of victims of Nazi crimes sued Germany before Italian domestic courts, claiming damages. So damages claims. So we are not talking about criminal responsibility here. So the important distinction between criminal responsibility of the individual criminals is one thing, and the other thing is the civil liability of the state for the damages incurred by the victims of Nazi crimes. So we are within the domain of civil jurisdiction. So it was a civil judge in Italy which has been invested by claims, seized by claims of reparation. And a number of domestic judges started, including the Court of Cassation in the famous case, the Ferrini case, followed the course of action whereby a limitation to the sovereign jurisdiction of Germany could be envisaged. And this would involve major problems of a financial nature for the Italian and well, first for the German budget, and indirectly for the Italian state budget, in case Germany would be held liable, and then Germany would have asked Italy to pay for what Germany would have considered money paid out of an unjust, unfair application of international law, because Italy would claim that there is still an international customary rule on immunity from civil jurisdiction, except for conduct concerning private business.
So if I may interject, okay? So this was really, the political situation was, I remember I was in 2 advisory boards at the German Foreign Office, and of course this was always on the agenda of our meetings. It started out with Greece, where you had more or less the same situation. The German troops, the SS, the Gestapo had murdered whole villages, etc., etc. The people went to the Greek courts. The Greek highest court rendered a judgment like your Corte di Cassazione, like Ferini, more or less. And then, of course, Germany kind of did what it could. Let me express it in friendly terms to make Greek government, please do something. And the Greeks pulled out of a hat like a rabbit a special court for this kind of international problems. And that court finally found that no, the Areopagos was not right. There was, you couldn't sue Germany because of the sacrosanct principle of immunity. And then you had the Greeks going to the European Court of Human Rights in Strasbourg. Again, no luck. And then they learned about what happened in Italy, so they joined they joined Italy. So you had the Greeks and the Italians. Now, normally, I would say if something like that develops in a country, the government would be, let's say, sympathize with that. But that was not the case at all. Because, of course, and the reasons would be interesting to explore. I don't want to intervene in the domestic, let's say, little secrecies of Italy. But of course, one fact was that if that was recognized, that maybe Italy would have its own skeleton in the backyard, maybe some Libyan skeleton or some Ethiopian skeleton dating back to the Mussolini times. I mean, the German crimes happened in the early 1940s, and you had a lot of Italian, let's say, mass murder, etc., going on when Italy wanted to become a great power and establish colonies in Africa. So that was one reason. Another reason certainly was friendship between the two countries. Both are members of the European Union. They are more or less committed to treat each other nicely, and so this kind of thing doesn't come as a pleasant surprise. But of course, the problem was...
Sorry, Bruno.
Yeah.
If I may add or complement, and
okay.
What you are just saying is one of the reasons why Italy and Germany, I mean, the foreign ministers of Italy and Germany met at some point in Trieste and said, well, we will go before the International Court of Justice, which will assess the state of international law, whether the Court of Cassation is right or wrong. Is the Court of Cassation right in saying that there is an exception to jurisdiction immunity? So then we'll put clarity into this system. And it also accounts your explanation for the fact that the representatives of the Office of the Attorney General, Avvocatura Generale dello Stato, appeared before the Court of Cassation in Italy, pleading for the immunity from jurisdiction of Germany under international customary law. Interestingly enough, the same...
My favorite newspaper is the Süddeutsche Zeitung, and I remember a long interview with the then Italian foreign minister, who said that this is really a problem which it should be solved by the International Court of Justice. but of course, as a friendly way. But of course, it's not as such a friendly way to sue another country before a court. And the foreign minister said, but there is no other way. So Germany would have to sue us. And now I don't read his thoughts, but he probably thought, and we all hope that Germany will win and Italy will lose. And that's the way it happened. The German government, the Italian government must have been more or less satisfied with the outcome. But that didn't really lead to the end of the story, right? As we know,
Yeah.
Was it October 14 or October 2014? I'll let you add the Italian.
Yes. Yeah, I mean, Italy was somewhat relieved by the outcome of the decision of the International Court of Justice, saying that there is an international customer law which has not undergone any modifications with regard to this kind of civil actions. So, as you said, normally you would expect that the situation in which a state sues another state before an international adjudicative forum would be taken as an unfriendly gesture. But in this case, there was a mutual understanding that Italy would also be pleased to have this situation settled internationally, so that the government would not take political responsibility and that domestic judges would comply with the decision of the International Court of Justice, sparing further occasions of conflict between Italy and Germany, and with the complications that you mentioned for Italy concerning conduct of its past conduct in Africa, for example, and also sparing Italy of the risk of having to compensate Germany for the compensation that Germany would have had to pay before the Italian courts. So once the decision was rendered in 2012 by the International Court of Justice, the Italian government introduced a bill into Parliament which would provide for the full implementation of the decision of the International Court of Justice to the effect that domestic judges could not exercise their jurisdiction over Germany for the conducts complained of, which we have just been discussing. And at the same time, Italy would ratify the United Nations Convention on Sovereign Immunities. Fact is that the domestic judges seized of these cases, a series of these cases. One of them, Florence judge, asked the Italian Constitutional Court to decide as to whether this piece of legislation implementing the decision of the International Court of Justice was compatible with the Italian Constitution. And rather appallingly, the Italian Constitutional Court, with the court decision 238, I think it was end of October indeed, 2014, said, well, we think that the international obligations stemming from the judgment of the International Court of Justice is banned, is prevented from entering the Italian legal order because it's against the right to access to justice. And we know that this would be in breach of international customary law, but we purport to change the law. This has caused major problems, and now the floor is with you, Bruno. How is this perceived in Germany, and how would you think this may impact future relations between Italy and Germany, and whether this may bring the case before the ICJ again?
But there was, I think, I remember that after the judgment of your Constitutional Court, there was, of course, not an expectation, but a fear that if Germany might go before the ICJ, would have to go before the International Court of Justice again and sue Italy for not implementing a judgment of the International Court of that would of course has been a terrible situation. So my personal views are I'm a bit torn about that case. I said I took part, and of course as the German judge in a case brought by Germany against Italy, you were I think under a certain degree of higher attention and control. What is the German guy in the court going to say about this or that? But I think the ICJ did not have a choice. It has to decide on the basis of international law. It cannot make decisions based on considerations of, let's say, humanitarian considerations, equitable considerations, justice, if the parties do not authorize the court to do so, which they could, but they didn't do it in that case. So the court had to decide on the basis of the customary law as it existed. And it came to the conclusion that even though domestic courts in some countries, above all Greece and Italy, had rendered decisions saying the immunity of a state for war crimes, crimes against humanity, genocide, cannot be retained. There has to be a sanction, and this sanction means immunity goes away and the state remains responsible. But this practice remained remote, was not enough to change the state of the customary law, and therefore the court rendered the decision that it did. Italy lost. But it's interesting that there are two little passages in the judgment where you can see this kind of, let's say, problem. The court says, okay, we are talking about the, let's say, compensation for civil internees, let's say, for Italian soldiers brought to Italy, or maybe private persons, brought to Germany for forced labor and terrible treatment, many of them dying, etc. This is not such a big, so why didn't Germany do what it did vis-a-vis all kinds of forced laborers all over the world? Why didn't they include the group of Italian, I think they were called IRIs? Why didn't they do it? And so the court said, it is a matter, for the court, it is a matter of surprise and regret, concern. So the court says, okay, Germany, you win. Congratulations. And in the same breath, the court says, but for us, it's a matter of surprise and regret that you didn't do what the Italians wanted you to do. This is extraordinary. This is extraordinary. And of course, I cannot tell, I'm bound not to speak about how such a phrase comes about in a judgment, but you can imagine what kind of let's say, conversation we had. And then there is another paragraph in the judgment which says, this judgment does not stand in the way of negotiations between the two countries about compensation, which was, I mean, when you read the text, I fought for a phrase which would have read, this does not exclude, or the court would maybe welcome, something like that. The actual phrase is very neutral. It just says, does not stand in the way of negotiation. But of course, it's meant to be a, how should I say, a suggestion to Germany. Come on, rich Germans, do something for these people. But as far as I know, Germany didn't do anything. The main reason being that they, of course, think that if they start compensating one group, the next group will kind of come up and say, me too, in the old-fashioned sense of that phrase, right? So, and of course, at the moment you have some Greek demands coming up again, and you have demands by Poland, for instance. Poland says you have done so many terrible things and killed millions of our people. So the sum of compensation, and we consider bringing that before the ICJ, So Germany, I think, has some political reasons to say, unfortunately, we can establish some kind of foundation in memory of these things that happened, and et cetera, but not pay, because this would really be a slippery slope and it would lead to huge compensation demands. So in a way, I understand Germany. On the other hand, it is the judgment didn't satisfy me, and so at the conference actually at Lago di Como a few years ago in Villa Vigoni, which was, maybe you can explain that in a sentence what the role of Villa Vigoni was. There was a conference about that, and I took the floor and said in public that it is a shame that the two countries, I think it should be done, should establish a fund, should establish a foundation, and some money should go into the direction of these people. It should not be for Germany alone, because I think the two countries, I think the same reason that you described, the two governments being unhappy about what happened, they should do it together. They do up. But as far as I know, nothing has happened yet.
Yeah. I remember I was with you at Villa Vigoni, which was a very symbolic location for the two governments to hold that meeting, because the Villa Vigoni, beautiful building on Lake Como, is the seat of the German Cultural Institute, and had been subjected, or was meant by domestic judges in Italy to be seized as a form of pignoramento, sequestro, which eventually, because international law is complicated, you have a customary rule on jurisdictional immunity, and you have another rule on the immunity from execution. So there is no doubt about a piece of real estate used for public purposes to be executed. But that was interesting. I would like indeed to stress that it would have been more fortunate language if the court had encouraged the parties to provide for some equivalent formula for compensation to the heirs of the victims. And in fact, the Italian Constitutional Court, back 20 years ago, when was seized of an issue of constitutional compatibility of jurisdictional immunities, said the constitutional right to, also enshrined in the European Convention for Human Rights, right to access to remedy, immunity may be compatible with this constitutional right insofar as there is a form of equivalent satisfaction whereby there is non-judicial compensation. So the International Court of Justice gave the parties this opportunity to grant the right to remedy via a non-judicial means. So you don't breach the customary rule on immunity, so there will be no judge demanding and enjoining Germany to pay compensation judicially, but you will have an equivalent formula. This could have been made explicit in the Italian piece of legislation that would implement the decision. Fact is that at the end of the day, we have this constitutional court decision. Bruno, if we can move forward from this particular case, I would like to link our discussion to your statement about boundary disputes as being typical of cases in which states give in to adjudication. And this brings me to a consideration whereby there are domestic, administrative, and political reasons why politicians in one country and in the other country, administrative staff, feel at a loss when there is a dispute and don't dare to get to a negotiated, diplomatic, political arrangement with the other disputing party because of internal reasons. There may be political reasons and there may be also legal reasons. For example, in case you make boundary delimitations, normally disputes about boundary delimitations take one case pending before the ICJ between Somalia and Kenya. The Italian energy company is exploring, is planning to exploit oil resources on the sea, engage into refinery, oil business. So they enter, so you have a foreign big oil company which is entering into a public contract with one of the two disputing states. So the territorial scope of my contract is disputed. And at a certain point, because of the dispute, the whole business is blocked. So potential revenues for both countries is being prevented from running. There is no income coming from exploitation. And state A claims 100% of the disputed area. The other state claims 100% of the disputed area. It would be mutually beneficial at some point to come to an agreement. But because of domestic political reasons, the people in government who come to an agreement may be accused of either being corrupted or to be weak. They cannot take the political responsibility. Similarly, a high-ranking state official who writes a memo saying, we suggest that based on all maps and this and that, we should give to the other party 25, 30%, is being accused of some responsibility. And for the true benefit, they say, let's avoid political responsibility and ask the court to decide the line dividing. So there is a domestic element which bears on how much foreign policy decisions depend on political domestic issues. And I may add in due course some considerations about the Italy-India case about the Marines, which occurred recently. But what is your sense, your sentiment about domestic legal and political considerations with regard to this tension or synergy between adjudication and diplomatic settlement of disputes? In the end, even this Italy-Germany case very much reflected domestic concerns.
Well, Attila, while you expressed the problem, I kind of thought of two cases where this precise point came out very clearly, and two cases in which I was involved. One is an ICJ case, and one is a case where I was an arbitrator, but it was a case which is very close to Italy, because it's just across the Adriatic, and it was a dispute between Slovenia and Croatia, among other things about the maritime boundary. Now let me start with the ICJ case. This was actually the first case in which I appeared before the court as a member of the delegation, the legal team of Cameroon. It was a case brought by Cameroon against Nigeria. So if you very, very gently close your eyes and imagine the west coast of Africa, but open the eyes again, even though it's in the evening, there was, these two countries were fighting over a peninsula, Bakassi, terrible place, but that peninsula was important for the further drawing of the boundary in the Gulf there, full of oil and gas. And so you had oil companies sitting there trying to make money, and the hostile environment prevented them from doing their business peacefully. Then you had the two former colonial powers, the United Kingdom and France, exerting their influence. So finally, these two countries went to the court, and there was a litigation. And at the end of the litigation, Cameroon, my party, won. And then first it looked like Nigeria would yell but perform the judgment. But then what happened was that you had strong tendencies in some of the federal states of Nigeria who said, well, federal government, you may be willing to implement the judgment. We are not. It hurts us too much. So if you go ahead, this might really be a problem, and strengthen what you could call the centrifugal tendency in the federal state of Nigeria, which is a very hot political environment there. So suddenly, and then the government said, well, due to domestic reasons, we are not able to implement the judgment. And then came other actors on the plane. For instance, the then legal, let's say, the Secretary General of the United Nations, an African himself, who said, no, we have to give an example, and you are going to implement that judgment. And then you had a whole concert of non-governmental actors, oil companies, all kinds of groups, exerting pressure on Nigeria. And at the end, Nigeria sort of said, all right, we're going to recognize. They moved out of Bakassi. Cameroon took over peacefully. I don't know what agreements they have drawn now about how to, let's say, separate the oil fields there. But I think it's a good example, first, for the domestic pressure that you mentioned. Secondly, also for the, let's say, the role of diplomacy and non-governmental actors in the stage where you have a judgment, but the judgment is very controversial. And so there has to be a concerted effort of by all kinds of actors to get that judgment implemented. So that's just the first case. The other case was between Croatia and Slovenia, and you might have heard that there was a big problem which hit this arbitration, namely, it was published that one of the party-appointed arbitrators, the arbitrator appointed by Slovenia, had during the procedure been in touch with its foreign government, with its own government, and he got documents and he got suggestions about arguments and also how to influence other arbitrators. For instance, you can read all this; it's all published, and you can read things like the lady in the Slovenian Foreign Office telling him, hey, get in touch with Simma, because Simma has a good relationship with the president, who was a Frenchman. And then the guy says, that's very good, because I have been invited for dinner at the Simmas anyway, etc., etc. So very interesting little details. And this blew up, and you still wonder who, I say it openly, my theory is it was done by the Russians to create another split between European Union countries. I'm very sorry, but that is my assumption. And then Croatia said, Croatia, of course, had the idea or had gotten the impression that the case didn't go well for itself. And so the Parliament of Croatia unanimously adopted a resolution and said, this arbitration, we are not going to recognize any further work by this arbitral tribunal. Then came the Arbitral Award. I think it's a masterpiece. I'm very sorry, but I think it's very balanced. And I would bet that the Croatian government, the government again, would be quite happy with implementing it, because I'm sure they would not get a better decision by anybody, by any other award. It's a real compromise. But they cannot move away from that. They cannot say, all right, that's not bad after all, because you have this unanimous resolution by Parliament. And to overcome that feeling in the country is very difficult, and that's how things get stuck. The matters ended up before the European Court of the Court of Justice of the European Union. The court said, no, we leave that alone. That is your business, and that's where the matter stands. So it's another, I think, very graphic illustration of domestic, let's say, parliamentary democratic pressure upon a government to either get the case to the court or maybe not recognize the procedure any longer, etc., etc. Fascinating. To me, this is really fascinating.
Thank you very much for that. It was very, 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 very useful to hear you on this, and for our audience to see almost from close. It was as if we were there in the very events that you were describing.
You're also there because one of my favorite holiday spots is Caorle in the Veneto. And from there over, I think you would reach the contested area within maybe 30, 40, 50 kilometers, then you would be there. So you are really like people in a football stadium, watching the things. Yeah. Sorry, I interrupted you, Attila.
Not at all. Not at all. In your illustrations, in this interstate disputes, the relationship between international adjudication, domestic legal and political processes, you also mentioned the role of NGOs. And so the second red thread that I purported to follow in our discussion is the role of NGOs or non-state actors. Now, we have quite a body of international law which has been thriving for about 3-4 decades, which is in which you have taken and are still taking a major role, is investor-state arbitration. Now, this mechanism of dispute settlement was originally envisaged as a means to encourage foreign direct investment, depoliticizing potential disputes between states concerning the treatment of foreign investors. I remember my first case, I was a young advisor in one of those cases in which out of facts which occurred in 1968, only in 1985 did the United States sue Italy because of an alleged case of indirect expropriation of a United States company. And in fact, this was another case very much in line with what we have been discussing before, in which both the United States and Italy were very happy to go before the ICJ. But this was a very exceptional situation with regard to the treatment of foreign companies, where you would have problems politicizing the dispute when a foreign company could be defended through diplomatic protection. So the idea of creating a system of arbitration whereby the foreign company can sue a foreign state would encourage foreign companies to invest abroad, feeling fairly confident that they would not be at the mercy of a foreign domestic judge or at the mercy of the political will of its state of nationality to espouse the case on the international level. Now, this system has indeed catalyzed a major increase in foreign direct investment until at some point it was not just developing countries which complained about the system being sued by major foreign corporations coming from industrialized countries, but I think that a number of industrialized countries, including Germany, when it got sued because of the termination of the program of nuclear energy, and a Swedish company sued the government of Germany for closing down their plants, the United States being sued by Canadian companies. So there is a sort of a killer kiss and hug between nationalistic state trends by states on the one hand, even conservative states, I would say, and activist, leftist, anti-transnational corporations that are firing, getting the investor-state system into a crossfire, trying to kill it. I suspect that through this crossfire attack, we risk to throw the baby out with the bathwater, because in the meantime, states engaged into a process of modification of treaties which provide that the applicable law by investment arbitrations and arbitrators is to become more and more concerned with the protection of collective and public interests. So if we demolish the system, it is highly likely that foreign direct investment getting into some kind of disputes will become just contractual disputes before purely commercial arbitration panels. What is your sentiment about this? And where do you think the debate stands, and what are the prospects, Bruno?
Attila, you set the problem out in a very graphic and clear way, and so a lot of it you have already said. So my own view would be, of course, the arbitrations I'm involved in help they kind of improve my pensions a bit, so they have their good sides. That is obvious, of course, but this is not decisive. I think the decisive point is really that the investment arbitration was really meant as a thing that operated from the north to the south. That is, let's say big corporations, investors from the north invest in the south, with all kinds of neo-colonialist movements, etc. And there they establish a certain protection. And then the system turns around, and you mentioned the Vattenfall, and Germany discovered, and they thought, this is not meant to go against us. We're very sorry. How can you? I mean, we are, rule of law oriented states. Our courts are independent and objective. So all these terrible, let's say, things that you hear from countries further down do not let's say, exist in our country. And I think this led to this let's say, coalition that you mentioned between the anti-corporation, let's say, capitalist movements and the states, also finding the system more or less dangerous for themselves. I think that the problem is there. I still think it has its raison d'être. I would go as far as saying, if you follow the domestic jurisprudence, even in some of the member countries of the European Union, you could get a sleepless night if you were an investor in these countries. I'm not going to name things, but so I think there is still a place there. But of course, the European Union claims there is no place for you there anymore. We are going to take care of this by our own means. And so there is a big debate now between the European Union and the let's say, foreign countries. And recently an agreement has been concluded. It's not yet in force, but an agreement has been included between the great majority of EU member states, which say in our countries, between an investor from one of our countries and another one of us, such investment arbitration is not valid anymore. It's just outlawed. And I think you'd really have to look very close. And I'm not a European Union lawyer now in knowing things in great detail, but I think the point could be made that the European Union law on the protection of foreign investment might not be at the same standard as the standard, let's say, established by the jurisprudence of these arbitration courts, the investment arbitration courts. On the other hand, I have to say there are a number of practices in that investment arbitration which I personally find awful. I mean, this is also something a bit problematic for me to say but I have to, in almost all cases in which I sit as an arbitrator, I'm the presiding arbitrator. So I'm out of that problem. But what you see is you have arbitrators appointed to take one particular view, let's say a view protecting the state, in favor of the state, which in other cases work for corporations. It might rather be the other way around, but they plead as counsel, as advocates before in other investment tribunals, they plead exactly the opposite. Or so that the so-called double hatting, and this is a problem which I think should be confronted really with more energy than it is the case, because of course I would say out of the, no, Attila, I don't know how many you would count, but maybe about the 50 people who more or less monopolize this field, and you belong to that group also, I've heard. I think there are many people who are not professors or independent arbitrators, but people who work in big firms, and they are either appointed as arbitrators, but they are more interested at being appointed as counsel, because their law firm, of course, makes a huge amount more from representing a company in a case than an arbitrator makes. So there are developments and things there which I find they need to be either abolished or improved. A lot of that happens actually. So the UNCITRAL, a UN organization, is working on that. There have been periodic conferences. A lot of improvements have done. States exempt certain, let's say, fields from the grip of the investment arbitrators for public policy purposes, etc. So I think we should not, and just to quote you, throw the baby out with the bathwater. The European Union is developing or is propagating a system where you have arbitrators and then you have some kind of a arbitration court of appeal on top of the arbitrators, which again is a good idea, but with a lot of problems, like who are going to be the arbitrators? They say, well, it's not going to be lawyers, it's going to be more retired judges, this kind of people, which again creates problems of all sorts. One big problem that all these people are actually appointed by the state, and the states are going to, or the European Union are going to be parties in these proceedings. This is something which reminds me of a big problem of the Corte di, how do you say, the sports arbitration, Court of Arbitration for Sports in Lausanne, where one big problem is that the arbitrators are all appointed by let's say, a power, which is not an objective power, but which actually the organized sports. So, just to make the long story short, I think the investment arbitration business should stay, but it needs to be improved on many fronts.
Thank you very much, Bruno. Yes, I'm totally with you on double hatting, and in fact, I noticed that you may have issue conflicts of interest if you have expressed your views on in an article of yours, which may bear even indirectly on the subject matter of the case, and that would be a problem. Whereas one is surprised to see that an arbitrator appointed in one case has been pleading the year before for one of the two similar positions, and that is unsustainable. And but for the rest, I really think that the whole system is providing increasingly protection to public interest concerns, environmental concerns, human rights concerns at large, which these treaties are part and parcel of the applicable law by investment arbitration panels. And if the system breaks up, the same kind of economic activities will not be subject to the scrutiny under the yardstick of these international treaties, which now provide for protection of health considerations, human rights, and other environmental concerns. Now, an issue related.
Sorry, I'm so sorry to interrupt you, but unfortunately we have just a few minutes left, and there are some questions from the participants. So maybe you can look at the questions.
Matilde, before we look at the question, can I put one last question to Bruno Simma, because he has been leading an interesting debate which may lead to a groundbreaking international treaty, maybe, which bears on business and human rights.
And we have just to finish in 30 minutes maximum.
Yeah, so
okay.
Do we have 5 minutes for this question?
Yeah, it's okay.
So Bruno, can you tell us a bit about this process which you have been informally or formally leading, just to set the scene?
Yeah.
We have had in the past cases of an extraordinary dramatic relevance. The Unocal case, Kiobel case, you have foreign corporations doing business abroad and cooperating with armed forces for the security of their workings, and engaging into extermination, expropriation, burning people alive, and I'm referring to the Unocal case, Kiobel. And the victims and the heirs of the victims, family members suing before domestic courts of the country of the mother company. That was the scene. Depending on the mood of domestic courts abroad. Now, Bruno, where do we stand with the idea of trying and putting some uniformity into the law of these kinds of situations?
Okay, I think I'll be as brief as possible. You set out the background very, very, very well. Like the example would be like Bangladesh. Let's say safety regulations are, of course, not followed. A big fire erupts, a building just kind of collapses, and hundreds of people are victims. Where can they go? They could go before the courts of the country in which this happened. I would say maybe these courts are not always the right, let's say, instance for the rights of people like these to go against foreign companies and very influential, let's say actors. And so we tried to fill a gap, and we have developed a system of arbitration. And I would say that the model case would be there is a European company, and it produces, let's say, or it buys and sells textiles, and there is a so-called supply chain. So that is really the decisive term, the supply chain. And there have been many cases where people went to the British court, to a German court, and said, we are victims of something that happened in Ruritania in Bangladesh, but our factory produced for a company which again supplied your German British company with these shirts or whatever. And so the problem is, or is how can the company at the end of the supply chain in our countries be made responsible? And there is a movement underway under the auspices of the United Nations, and a number of countries is actually adopting laws which make the European, the domestic companies responsible for a lack of what we call due diligence in monitoring what the people in countries like, the companies that operate in countries like Bangladesh, whether they really conform to all the standards that there are. There are many standards there. But as you said, British courts, French courts, German courts, Italian courts have not been enthusiastic. And so what we have produced is a system of arbitration, which is voluntary and which might help out. And actually, a couple of arbitrations have already taken place, not on the basis of our, let's say, the rules that we developed, but earlier, which showed this makes sense. And just I'd conclude, if you are interested in that, just go into the internet and look for what is called the Hague Rules of Business and Human Rights Arbitrations, and you will find everything that we don't have the time to go into. So it's a baby which was, let's say, how should I say, I took part in its production with a lot of, let's say, emotion and enthusiasm, and I hope it will be successful. Okay.
Thank you, Bruno. Matilde, we are in your hands. I see that it's 7:04 p.m. We have the rest available for questions from the audience, from the floor.
You can read the questions, or you cannot.
I don't see any question.
Okay. Okay. So I can just.
I think that probably I would have exercised some degree of self-constraint, but I think I only see that there are 87 participants.
Yeah.
3 plus 4 speakers.
So, okay, who sees where the questions are being put? So this is just emails that reach you, Matilde, or?
No, everyone can read them. If you just look down, it's called Multimedia Viewer. And in the section Q&A, you can read the questions.
Okay.
Well, I am there, but I'm in Multimedia Viewer.
Actually, I don't see that it says 0. So we must have been either very bad and very important.
No, I can read them. There are some questions.
Yes, I managed. Thank you, Matilde. Anonymous. Bruno. Well, I see them. As the case of the survivors of the Holocaust shows, do you not think that a crime against humanity cannot decay? I wish I could answer immediately, but Bruno, did you get this question? It's basically non-prescription of crimes against humanity. There is no doubt about it.
I think that crimes against humanity are a category of crimes where prescription, in my view, cannot enter the picture. I mean, they have to do with murder, etc. And for instance, murder is a crime which, independently of any international or Holocaust connections, is not subject to prescription in our domestic criminal statutes, and the same is valid at the international plane. The question is to the person who asked the question: does he or she have a special case in mind where the opposite happened, or is it? So that would be interesting. I don't know whether it's possible for the people who asked that question to become more specific.
Well, you know, Bruno, I believe that this question possibly comes from confusion between criminal and civil liability responsibility. I mean, I think that it was the first or the second General Assembly resolutions which announced the principle of the non-application of the statute of limitations, no prescription of international crimes, of war crimes, or crimes against humanity. But if this question was put in relation to the jurisdictional immunities case, we are not talking about the individual criminal responsibility, which may not be prescribed, be barred, time barred because of statute of limitations. We are talking about the civil jurisdiction of states. So this is Hikma and the rest of them still, Nazi criminals being still sued, tried, and that is not the point. Has Judgment 238 had an international impact on the relevance of diplomatic immunity? If so, how has it changed? I mean, probably the question is, has the Italian assessment of the restriction of the customary rule on sovereign immunity been successful between 2014 up to 2020? Perhaps, Bruno?
Okay. Okay. I take the opportunity to answer that question slightly, or maybe with an idea of my own, which starts from what I said before, that I'm not an enthusiastic supporter of the ICJ judgment. I'm not a diplomat. If I had to choose between the position of a governmental lawyer like the people in Berlin and the people in Rome and a human rights lawyer, I would side with the human rights group. And of course, the expectations of the human rights community were huge. This is the occasion for the ICJ to show that it has a human face away from this cold bilateralist interstate business, etc., etc. But as I said, the court have to decide as it did. But for me, the interesting question now would be the following. I am quite familiar also with parts of the academic, let's say, actors in Italy. And there was one name, Benedetto Conforti, who was a professor in Naples, very influential, and his textbook, Lezioni di Diritto Internazionale, I think, might probably be still in use. If you look at the Corte Costituzionale in 2014, if you look at the names, you see this is interesting, because you had the president of the Corte, you had a public international lawyer at that time, who was actually some kind of pupil, maybe not formally, of Benedetto Conforti. So what was Benedetto's reaction to the judgment, of the ICJ in 2012? He said, this is awful, of course, and we are all disappointed, but there is still hope. And then he reminds us that some of the first court decisions which kind of carved this exemption into state immunity for acta iure gestionis, that is for commercial activities, that if a state acts on a commercial level, it does not deserve immunity, was actually done by Italian courts. There are some of the leading cases in the late 19th and early 20th century were made by Italian courts. And so Benedetto Conforti says, so why shouldn't the Italian courts start again and continue trying to carve out another exception, namely no state immunity for crimes against humanity, war crimes, etc., which is a very interesting thought, actually. And so for me, the theoretical question would then be, okay, how would, let's say, an Italian court, what would it look like? What would it be if the Italian courts just continues to adjudicate that Germany does not deserve immunity for some instances that happened at World War II? you have in other countries, you have courts taking similar views with regard to other crimes, heavy crimes. So the situation would be as follows. The ICJ has, is there an Italian word like it has established the law in 2012 is as such, no exception. But does that mean that that law is carved in stone now? I think it can still move ahead. But probably in such a case, that these domestic decisions would look like violations of the international law as sort of established by the ICJ, is confirmed by the ICJ. So they might look as violating the law, terrible, terrible, terrible. And how about the honor and the authority of the ICJ? All kinds of things. But they might be able to change the law. So there is still potential for domestic courts to change the state of the law if you are daring enough, if you are courageous enough. And maybe Italian courts should just continue. I know I'm kind of, as a German professor, I'm kind of I'm sitting on a tree and more or less cutting the thing on which I sit. But let me just say, there is still hope also for the human rights community there. It is not impossible for constitutional law to change, to develop. Maybe this is a bit into the direction into which that question went.
Thank you, Bruno. I don't think that...
Actually, I see from your face that you don't like what I said, right?
Who, me?
Yeah? No?
No, I think, yes. I was just about to say that in the abstract, you're absolutely right. If Italy goes on following the 238 Constitutional Court decision, that may be a signal moving towards change. I haven't seen an overwhelming or even any significant number of domestic decisions along the lines of 238, but there is an interesting case pending before the United States Supreme Court about these days, about the expropriation of cultural property brought about by the Nazi regime during the Second World War, which is now being disputed for compensation before the Supreme Court. And isn't it that expropriation carried out within a scheme of extermination and genocide, perhaps the subject of limitation? We'll see what the US Supreme Court will say in a few months' time. In your reply, Bruno, you mentioned disillusionment and hope. Let's get to Benedetta's question, which goes to the heart of our profession, academic profession mostly, but also as international practitioners. Benedetta asks, what is nowadays the role of public international law in the international arena? Does it have an impact on international relations? Do politicians take international law into consideration? Is there a possibility to see some kind of schizophrenic approach whereby you have judges and lawyers in general taking international law very seriously and politicians very, very little seriously? What is your sense about the role and the impact of international law in international relations nowadays?
Let me reply with in a sort of anecdotal way. As Matilda said when she read out my role in establishing the European Journal of International Law. The European Journal of International Law is currently its 30th year, 30 years. And so Joseph Weiler had the chief editor had the idea to let some of the early, let's say the founders, write little exposés about how they saw international law in 1988, when the idea was born to establish a journal, and now in 2020, about 30 years later. And I thought about it a lot, and I thought about it a lot, and at the end I gave up and I wrote back and said, I'm afraid. And then the idea was that young people, the people behind the journal or running the journal now, would then give their comments on what the old guys had said. And I was not able to furnish such a paper, and mainly for reasons, for very, let's say, pessimistic reasons. I thought that what we see at the moment is not good for international law. I unfortunately see that its influence is decreasing. A lot of it goes back to how the leading country and the leading power in the world, which since 1945 has been, of course, pursuing its own interests, but also maintaining a multilateral system of treaties, alliances, etc., namely the United States, is hello, am I still heard?
You are there. I hear you.
I'm out of the picture. It says, thanks for using Cisco WebEx. And otherwise it's blank. But I just continue talking. So what Trump is doing to international law is creating wounds, which hopefully his successor hopefully will have a successor, and will take a very long time to heal with it all. So unfortunately, not good times. The influence of international law is not, but of course you have areas where international law works, like any part of healthy domestic law, like I don't know, some say commercial law, for instance, parts of human rights law, they work well. But the great questions like use of force, etc., etc., I'm very pessimistic, and I'm not. And the growing role of China doesn't make me optimistic again. I'm unfortunately.
If we have time, there is one question.
Can somebody help me getting back into the picture, because somebody must just kind of.
Matilde, do I have time for? I see one question.
Yeah, I'm fine.
It's very interesting, Matilde. This question asks Judge Simma to illustrate what he thinks are the turning points in recent history since the Second World War that have deeply influenced the direction of international law. And I would perhaps add, in what respect can we see international law having influenced the conduct of events since the Second World War? What are the major developments of international law, and in what respect international law has helped the development of international relations and politics?
Mamma mia, another one of these questions where you would need a seminar and many hours to. So is the question directed, was there an event or a development between 1945 and nowadays that has been particularly, let's say, influenced the status, the power of international law? What I see since 1945 are essentially events and developments which, if by 1945 I understand the multilateral system as it was established in the 1940s, in the 1950s, alliances, etc., economic organizations, etc., etc. So, I mean, you could say, of course, everything that came about after 1945 was very impressive and helpful, and you had a functioning multilateral system. But the question probably is more directed at more recent times. And in more recent times, I just see dangers and erosions and cracks in the building of international law. Like 9/11, in 21, and the impact it has on use of force. Again, I think nothing stands out as a particularly positive development or some, let's say, great move to the positives, to the development of the law, unfortunately.
Thank you. I think that should be about it. I certainly say that I may add that I think that international law.
Maybe it's just because I'm getting old, you know, and old people become pessimistic, etc., etc. But I think it's very difficult to find positive developments nowadays. Sorry, Attila, for interrupting.
Not at all. Sometimes I compare myself in sharing your pessimism to what must have been the view of an international lawyer in the mid-1920s or 1930s. But then there has been new hope after 1945. But all this pessimism only accounts for the importance of the basic consideration that the law is the reflection of the social process. And we live in a period where there is very little social normativity and consideration for shared regulations. Certainly, international law was very positively affected by the end of the Cold War. And they say between 1989 and 1994-95, international law thrived. The Charter of the United Nations got perfectly applied. The Security Council was unanimous. But then the problems in the Balkans could not be settled by international law. But it was not because the United Nations or international law were not good enough because of the legal rules or the Charter of the United Nations. It was just because the International Society of States could not come to a solution. So there is no good law which works well where there is no homogeneous and harmonious society. And the society of states is what we have around, as much as we have around a society of individuals. So don't overestimate the role of the law. That's why it's good that you have political scientists that study the social process. International law or any law is just part of the social process. Good social process will produce good law, but you cannot expect the law to change a society. That is my
agree. Yeah.
Do you agree, Bruno?
Very much.
Better to be good citizens than good lawyers.
Sorry?
It's better to be good citizens than good lawyers.
I think the ideal position would be to be a good citizen and a good lawyer. But yes, recognize that not everybody can become a lawyer. Also, fortunately for our profession. Now, Matilde, are you still listening in?
Yeah.
I think at the end there would be some kind of a personal interview or something. But I guess that time is up for us. So I think that maybe some of the final remarks that I made showed what kind of, let's say, emotions or sentiment I have about what I have been doing during my life. So I have enjoyed it, and I'm still enjoying working in international law a lot. I'm ending up in a chapter of international law, which is very much alive, even though very controversial, like international commercial law, Iran-US Claims Tribunal. So, but let's hope that other areas of international law will improve in efficiency and effectiveness, and in that, because the young people, will have to live with that stuff, and will have to suffer from things that we neglected and on which we didn't pay enough diligence. We haven't mentioned climate change and all that stuff. So I think people like myself and maybe Attila, who is much younger than I am, have no real reason to be satisfied with what they have done. I think we still have to try to do better. And I wish you all the luck. And I really like Italy, and I like Italians, and I like students. And so I hope you will do well and become happy people, or stay happy.
Thank you.